morning. This is the House Judiciary Non-Civil Committee meeting of February 28th, 2011. We've got two bills on the agenda, House Bill 237, House Bill 87. We'll go ahead and take 237 first. Recall late last week we had what I thought a really good productive hearing and dialogue regarding the foreclosure fraud bill. We heard a presentation by the Attorney General and his team and some input from the Georgia Bankers Association or the mortgage lenders as well. The fruit of that discussion and that dialogue were some suggested language by the financial institutions, which you'll see on the back of House Bill 237. There's some language, especially on lines 29 to 32, on inadvertent errors and not wanting the law of unintended consequences to kick in. That has, I think, put us in a position to arrive at a compromise on that bill. Let me go ahead, I'll recognize the Attorney General's team right now to go ahead and speak to the specific changes just briefly. I think we have consensus, and then we'll go to a motion. So, Mr. Peterson, if you want to
Thank you, Mr. Chairman.
guide us through.
I'm joined by David McLaughlin, the chief of our Special Prosecutions Unit. And I had no idea this bill would excite so much public interest. There are three changes in the sub you'll see. As the chairman referenced, lines 29 through 32 was language that the financial institutions requested insertion. We had no problem with that. The two other changes, in line 42, the previous version of the bill after the first clause in any investigation of a violation of this article had additional language allowing subpoenas in other contexts, and there was a question as to, was that overbroad, and we just removed that additional language. And then there was a concern by Representative Pack and Representative Atwood about under what circumstances could an institution that received a subpoena move to quash the subpoena for overbreadth or being unduly burdensome. We struck some existing language and added the sentence at lines 48 and 49 to just allow any person to move to quash on any legal basis. In OCGA 24-10-22, parties that receive subpoenas are allowed to move to quash for a subpoena on the grounds that it is unreasonable or oppressive, and this just incorporates that ability. Doesn't add or subtract any existing legal authority, but makes clear that everyone can operate under that.
Thank you. Any questions for the Attorney General's office about the substitute or the changes? Seeing none, what's the pleasure of the committee?
Move due pass, Mr. Chairman.
Vice Chair moves due pass, second by Mr. Pack. Any further discussion? Are there any amendments? All in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it. The motion is adopted. Let me thank you, gentlemen.
Thank you,
Appreciate
Mr.
your
Chairman. And thank you for your leadership on this issue.
Thank you for yours. Please tell the Attorney General we're happy to help in any way we can. Let me call House Bill 87. Let me ask Representative Ramsey, Chairman Ramsey, if he would, just to, you can do it from there. It doesn't matter to me. Okay, no, that's fine. Whatever's comfortable. We have a substitute, a proposed committee substitute on House Bill 87. It's what you have in your folder should be LC 294654 S as in Sam. LC 294654 S as in Sam. You also have a memo from our legislative counsel, Jill Travis, and this is in consultation with legislative counsel Terry Long, about some technical, purely what we would call here cleanup changes that were made yesterday that were not reflected in the substitute that you received on Saturday. I would invite you, as Chairman Ramsey goes through the changes that he has made to the proposed committee substitute for your consideration, as he goes through the changes between the as-introduced version and the current version. Naturally, I would encourage you to take a look at this memo from legislative counsel on those changes, but again, I would just stress that these are technical cleanup, and given the fact that we want to go ahead and get this bill as right as we can, so to speak, I felt it was a good idea to go and make those changes now as opposed to later. If we know we have to make changes, we do better to do them earlier rather than later. So with that, Chairman Ramsey, the floor is yours. If you would please just speak to the changes between then and now. We're going to hit, I know you're going to hit on the more substantive areas. I mean, to the extent that you want to hit technical changes, that's up to you. I think people are probably, as you know, most interested in some of the more technical. I'm sorry, in the more substantive policy changes that have occurred. And the floor is yours. Thank you.
Thank you, Mr. Chairman. And my intention is we spent a number of hours presenting a committee sub, our first committee hearing on this bill, and I'm going to touch on the 3 or 4 substantive changes we've made since that time. I would reiterate your suggestion to the committee to look at Ms. Travis's memorandum. We at the risk of engendering some lawyer votes, the chairman thought it might be good to have 2 lawyers rather than 1 look over the bill. And Jill took a look yesterday and had some very good suggestions. I want to thank her for that. We were on the phone on a Sunday night several times last night, much to my wife's chagrin during dinner. But I really appreciate the time that she put in, and certainly the time Terry Long has put in, the many hours we've spent in her office during the revisions to this bill, leading us to this point. We spent a number of hours presenting the bill about a month ago. Since that time, and at that time I described the process that had led us to that point, the hours and hours of public hearings we held in the fall, the hours and hours of meetings we had after we introduced the bill between then and the committee sub that we presented to the full committee. Since that time, what you have before you is a product that reflects another round of comprehensive, thorough due diligence, wherein my office has been open and available to anybody in this capital, in this state, that wanted to come in and sit down and offer an opinion or suggestion on this legislation. We have engaged in certainly the most thorough and inclusive process I've ever been involved in on a piece of legislation in my time here. And I believe the line, particularly a lot of the technical clarifying changes we've made throughout the bill since that time, I think reflects a better product because we've had more eyes on it and more people looking at the legislation. I want to particularly say thank you to the Republican members of this committee that have worked so hard in offering suggestions in the hours they've spent. Since the committee sub looking at provisions I've asked them to look at, vetting the bill, researching it, and again want to thank them for all the work that they've put into this. So with that, I'm going to jump in and kind of point out the few substantive areas that we've changed, and then of course would be happy to yield for any questions. In sections 2 through 6. This is where we are trying to right a mistake that was made when legislation was passed back in 2006, the intent of which was to limit access to public benefits by those that are legally ineligible to receive them. That legislation was SB 529, and the hole in that law that was passed, and briefly they require the state and local governments to collect E-Verify affidavits from public works contractors. It requires governments to enroll in the SAVE program, which verifies benefits eligibility of those that receive them, and it's a prohibition on sanctuary cities. The hole in that law was there was no enforcement mechanism when it was passed. It was a requirement, but there was no sanction. There was no method by which our state or our local governments who failed to comply could be held to account for that. So what we have done, as I presented in the original in our original hearing on this bill, was we are providing standing to citizens to seek injunctive relief for governments that are not complying with these code sections, these 3 code sections. It is narrowly limited to these 3 code sections. Working with our local government groups and on the suggestion of Representative Coomer, a very good suggestion, we have pulled in language from the anti-litem statute. There was a lot of talk about providing a cure period on the front end so that the government, the alleged violator, the government that is allegedly not in compliance, before litigation starts, we have provided a procedure by which the person alleging the violation has to give notice to the government. And again, this is just language pulled from anti-litem from other areas of our state code. And we give the government 30 days to demonstrate that they've come into compliance and show that whatever allegation that's been made, whatever they've asserted as being a basis for not being in compliance, they can demonstrate they now are in compliance, which obviously would then render the necessity to go forward with litigation null and void. We've also added an additional safeguard that if a plaintiff brings a suit anyway and the government believes they are in fact in compliance and it is a meritless, frivolous claim, we've borrowed a provision from another section of the code, actually the anti-SLAPP section of the code, that if the government brings a motion on the pleadings, a motion to dismiss, then the court will rule within 45 days, and during that time discovery stops. So that is an effort to if there truly is a belief that this is a meritless claim, the government brings the motion on the pleadings, then they're going to have an opportunity to be heard on the merits without incurring the costs of discovery between when the motion is brought and when it's heard by the judge. So those are the two safeguards we're very sensitive. We certainly don't want a rash of frivolous litigation. We only want this right invoked in situations where the government truly is not in compliance, so that our citizens have a right to seek a remedy when their government is not complying with a section of the law that we promulgated 4 years ago as a state legislature. Next, I would point to your attention Section 7. Section 7, 8, and 9 is brand new. It's the only new concept that we've added to the bill. We've heard through the hearing process over and over and over again about the problem out there that arises by people that are seeking to gain employment passing off fraudulent identification information, whether it's a fraudulent identification, fraudulent Social Security number. There's a market out there for the Social Security numbers of people that are deceased. There certainly is there is an identity fraud issue that we are abundantly aware of in this state. We've heard about it over and over again in this committee in recent years. And we worked with the Prosecuting Attorneys Council. Representative Pack really put a lot of work into this and sat down with the Prosecuting Attorneys Council and looked at our identity fraud statute and thought, what could we do to make sure that we have a specific theory in the employment context that our prosecutors can use to go after those that are putting our employers in a very, very bad position. Because ultimately, if a person gains employment using fictitious identification, and ultimately there's a raid of that facility, and the individual or individuals are found to not be legally eligible to work, it's the employer that's going to be in the position of having to explain how that person gained employment. This is just another deterrent to say that if you attempt to use counterfeit or fictitious identifying information for the purpose of obtaining employment, you will be guilty of the offense of aggravated identity fraud. We've provided for a punishment of 1 to 15 years and a fine not to exceed $250,000. It's just another tool we're giving prosecutors to go after those that put our employers in the state in a really bad position, and to serve as a deterrent to those that are attempting to gain employment through the use of fraudulent identification information. Next, I would ask you to flip to Section 11. We've worked with, this is the much talked about immigration status check piece of the bill. And we've worked with the Attorney General's office. Several members of this committee thought, is there a better way, in working with law enforcement, is there a better way to make sure that our law enforcement officers aren't put in the subjective position of having to determine or articulate whether they have reasonable suspicion to believe a person is in the country illegally before they can do an immigration status check. And if you remember, the last version of the bill said the part regarding probable cause to investigate a criminal suspect still exists. There has to be another predicate offense under which an individual, a criminal suspect, is being investigated. And in the last version of the bill, it said if during that investigation a law enforcement officer comes to develop reasonable suspicion that the individual is in the country illegally, they were authorized to do an immigration status check. But then, if the suspect can provide a list of identification then that would stop the inquiry. So there was a kind of a safe harbor, a driver's license. Really, you see the list of identifications we have here from 435 to 442. I suspect in researching this, and as we all research this, that reasonable suspicion was put in place by other states because they had underlying state offenses that criminalized an individual's status, a state offense that mirrors the federal offense by virtue of a person that is verified to be in the country illegally. We don't have that dynamic here. There is not a state crime that mirrors the federal crime based on status. So what we have done, we think, is remove that piece that requires an officer to make a subjective determination that a person is in the country illegally, have reasonable suspicion to believe a person is in the country illegally before they're authorized to do an immigration status test. And we've said now that an officer, in the course of trying to identify who the suspect is, and there's never been an investigation, a law enforcement investigation in the history of criminal jurisprudence where the law enforcement officer didn't try to figure out the ID of the suspect. I mean, that's pretty basic. And what we're saying here, if you can't give the officer one of these pieces of identification or sufficient information so that he can independently verify your identity. So in other words, I'm pulled over and I don't have my identification with me, but I can tell the officer my name and my address, and he can go pull me up in the DMV database and seek independent verification. If you can't basically give evidence as to your identification, then an officer is authorized to go forward with the immigration status check. So we've basically removed the reasonable suspicion and putting an officer in the position of having to articulate what that is. We believe it's unnecessary, and we believe this makes it a much sounder and cleaner bill. We've gotten some input from the Attorney General's office, and they agree with that assessment. We think this is a much better solution and a much cleaner way in terms of helping what our law enforcement officers are ultimately going to be enforcing out there on the roads. So next, I would ask the committee to flip to the E-Verify section, which is section 17, page 18. And I want to make a point. This isn't a change. But I was reading over the weekend a news report, a news story from a newspaper. I think it was the Macon Telegraph, which was ultimately picked up by the AP. And under the guise of a news report, they said that this legislation either at some point in the past or now has an exclusion in the E-Verify section for H-2A visa using employers. That is not the case. We don't have an exception for any industry in here. It's the same as it was that when I presented it to you several months ago or several weeks ago, and I continue to believe that the notion of picking one industry to be exempt from the requirements of mandatory E-Verify is bad policy. I have, however, I do, however, continue to have in there the same exemption we've had in all along that every other state that's done this has, which is an exemption for the mom and pop industries, the smallest of small businesses. I think that makes good policy sense. It's worked well in other states. But despite news coverage to the contrary, there is no exemption in here for an industry of any sort. So with that, the rest is largely cleanup, technical cleanup, making clarifying changes. And Mr. Chairman, I'd be happy to yield for any questions.
Questions for the author, Ms. Neal.
Thank you, Mr. Ramsey. We spoke before about a few things, and I don't see some of those changes because I was concerned about.
Let me interrupt the representative. I apologize. I think, members, what we're going to end up doing is we'll take one round. Obviously, if there's a question, then a natural follow-up from that question. The chair's not going to go ahead and limit that, but I think we will take one total round across the table just to make sure that's clear. I apologize.
Okay. No, you're okay. One of my main concerns was police officers being released from liability if, in fact, that police agency didn't have the money, the time, the resources, the staff to transport or house whatever illegal immigrant they might come in contact with. is there anything that can be added to release police officers from any law enforcement realm in Georgia from having to worry about that, including being sued if they didn't have the manpower nor money nor staff to transport these individuals to the federal facilities?
We have in the bill in two places a good faith indemnification for law enforcement officers that says if you're acting in good faith to enforce the provisions in the immigration verification piece, and then in another location in the bill we do have an immunity. It requires the officer to be acting in good faith, but there is no mandate. What happens to the criminal suspect if an officer receives a verification that that they are in fact an illegal alien, that then is based on what the federal government instructs them to do, whether they're issuing an ICE detainer on them, whatever they instruct the officer to do with that suspect. That's ultimately the governing body here. We don't, as a state, have the authority to deport anybody. We don't have the authority to carry out the functions of federal immigration law enforcement. But to your point, we do have immunity in there for an officer acting in good faith, carrying out the requirements of the section. So,
if I can have a follow-up. I guess my only concern is it doesn't explicitly state that, because I'm reading in line 467 in reference to the good faith. Acting in good faith to carry out any provision of this code section shall have immunity from damage or liability, but it doesn't state that carrying out any provision of this code section, including the inability to be able to implement.
I think that is legally unnecessary.
Okay. 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 Thank you.
Ms. Abrams.
Thank you, Mr. Chairman. Mr. Ramsey, looking at line 451, through 453, this is a question regarding Section 11. Can you posit a scenario where subsection B and subsection D intersect? My concern is that this states that you can be pulled over for a traffic offense, and that in the course of that traffic offense you can be inquired, there can be inquiry made into your immigration status, but your national origin, your race, and your color cannot be predicate acts for that inquiry. Can you describe a scenario where those two things can occur?
That language was left in there when we still had in the bill that the immigration status check occurred only after the officer developed a reasonable suspicion to believe they were in the country, the suspect was in the country illegally. Now the way it works, the way it's set up, is it's very objective criteria. If in the course of an officer investigating a criminal suspect they can't provide adequate information as to their identification, the whole list of identification that we've provided, or information that allows them to independently verify the ID, only then can the immigration status check go forward. Candidly, there is nothing about the way this is set up that could any way rely on a person's race, color, or national origin the way it's set up now. We had that in there before because we had, again, the subjectivity component. We wanted to make sure that the way it was previously constructed, there was no way that reasonable suspicion arose from a person's race or color or national origin. So I think there's nothing about the way this is constructed that is any way based on race. It's probably language that is wholly unnecessary at this point.
Thank you.
Mr. Vice Chairman.
Okay. Just friendly question for Representative Ramsey. Under the provisions of the requirements that an employer go through the E-Verify system, is there any sort of exemption that's written into this that if the E-Verify system turns out to be inaccurate as to an individual and an employer thereby mistakenly hires an illegal alien, that employer would not be in violation of the act?
Well, the use of E-Verify, how you use it, is prescribed by way of your contract with the federal government. The way we have the mechanism set up is that each year, as an employer, when you go to get your occupational tax certificate, some jurisdictions still call that a business license, you'll be required, among everything else you already have to provide, you'll have to provide an affidavit that says you're enrolled in E-Verify and provide your identification number. That's the only state requirement that we have. We are limited to using the licensing laws because of preemption issues on requiring the use of E-Verify. In the event there's a mistake made in E-Verify, that is why so many companies, we have 16,000 in Georgia right now that are enrolling in E-Verify, because the I-9 process that currently exists, it puts the employer in the position of looking at the identification and having to make the determination, are these documents sufficient? Do they comply with I-9? And you're putting the employer in the position of then defending that decision. The reason everybody's moving to E-Verify, or so many companies are moving to E-Verify now, is because it gives them a safe harbor. They have the federal government rendering a decision through the E-Verify process. This person's eligible to work. So I think E-Verify, that's one of the big benefits of the system, is that it gives protections to our employers. I had a meeting last week with one of our largest carpet manufacturers in Georgia. 30% of their workforce is Hispanic, they said. Yet they are going to E-Verify because it gives them a safe harbor from potential issues with the federal government.
So would I be correct in saying there's nothing in this bill that would provide for penalties against an employer who, in good faith, uses E-Verify and it turns out E-Verify makes a mistake?
No, there's not.
Okay, thank you.
Ms. Abdul Salam.
Thank you, Mr. Chairman. Representative Ramsey, I guess my question goes to unintentional consequences. We have another bill before this committee on human trafficking, and one of the concerns of that bill was that if we had victims of human trafficking who had been brought to this country illegally for those purposes, would they then be facing deportation because they had been brought here illegally under this scenario, under your bill? And I guess I'm curious on your interpretation of the legislation in this bill. Would they in fact be subject to deportation if they'd been brought here illegally as a victim of human trafficking?
The state of Georgia has no authority whatsoever to promulgate policies with respect to deportation. That is 100% the province of the federal government. I would point out to you, though, we heard from the advocate for the domestic violence lobby here in the Capitol, and in the section where we are creating criminal penalties for knowingly harboring illegal aliens, we've expressly said in that definition that harboring shall not be providing services to victims of crime, infants, or children. To your original question, no, there is nothing about this bill that will make it more likely for an individual to be deported, because that's not anything we could do, even if we're inclined to do so.
But could they be incarcerated?
Incarcerated for what?
For being here illegally.
No, not not based on this bill. The federal government decides who is incarcerated based on their status. That we don't have a status crime in the state of Georgia.
Okay, thank you.
Majority Whip.
Just to reinforce that point, there is already under federal law a safe harbor for folks who are brought into the country against their will as part of a human trafficking scheme to provide them with a certain safe harbor during the pendency of the criminal action.
Thank you. Mr. Pack.
Thank you, Mr. Chairman. To segue into what the Majority Whip and also Representative Abdul Salam was asking, I wanted to make sure I've gotten a lot of emails from people on both sides regarding the transportation provision in here, starting in line 344. I just want to make sure that the intent was there's a qualifier here that excludes all charitable organization, as I imagine it. The plain meaning of a person who, while committing another criminal offense, would exclude, for example, church members or nonprofit transporting refugees who happens to be out of state. Is that right, Mr. Ramsey?
That's right. And we also, since I think it was since the last committee, so I don't. It's very several revisions ago. This was added, but another qualifier that was put in that's in federal statute and in the other state statutes that have mirrored the federal statute is we've added the language in addition to you have to be committing another offense, but you also have to be doing it for the purpose of furthering the illegal presence of the alien in the United States. So it truly gets at what is your intent for transporting the individual. It has to be, A, you have to be committing another crime, but B, you also have to be doing it to further their illegal presence here in the United States.
And you would also have to be knowingly and intentionally, which is a pretty high threshold.
You have to know a person's, that's exactly right. That's exactly right.
If I may follow up, Mr. Chairman. And it looks like on line 358, for the stepped up penalties, there's an intent of making a profit or receiving anything of value. That's to get at the coyotes, people actually smuggling in, and this would actually provide an alternative way to charge people, traffic people into the state for the purpose of sexual slavery. Isn't that right?
That's exactly right.
Does that include domestic?
Sorry, did you want to ask that as a
I'm
follow-up
sorry.
to Mr. Pack's question?
Yes,
I know.
because does that also include domestic instead of sexual?
It would be any trafficking for any purpose, any human trafficking.
I see no further questions before. Oh. Well, we do. That's right, we did. That's fine. We'll make this the last question, Ms. Abrams. It's fine.
Mr. Chairman, Mr. Ramsey, the question I had, just following up on the furthering illegal presence language, isn't it inherent in the notion of furthering the illegal presence that unless you're taking the person to a space where they can be deported, that you are indeed inherently furthering their illegal presence? My concern is that while I understand the intent of that safe harbor language, that it doesn't accomplish that fact because the only way to demonstrate that you are not furthering their illegal presence is by taking them to a place that will lead to their deportation.
I can tell you every court that has construed that, a number of federal district courts have construed that language that's in federal statute, have construed it to mean exactly as I intend it to mean, which is if you're acting, you have to be acting knowingly and intentionally in an effort to offer assistance for the purpose of furthering their presence in the country illegally. It's not a person that's driving an ambulance, who I don't think would know the person's in the country illegally anyway. But to your point, I'm comfortable with the language. I think it accomplishes what we want to accomplish, and I think the courts that have construed this provision have said so as well.
Thank you. Thank you, Mr. Chairman.
Before we get to a motion, let me, so I don't forget, let me recognize our Judge of the Week, Sammy Osborne. Judge Osborne, where are you? Oh, right over there. I'm sorry. Thank you for joining us this week. Judge Osborne is Superior Court Judge in the Alcovey Judicial Circuit, which includes Newton and Walton counties. And what we tell all the judges who come in, if there's something that you observe during the hearing, we welcome the feedback and we welcome the input. We do better by having increased perspective rather than less, and the judges certainly give us that on an everyday basis, and we're grateful for it. So thank you for taking the time to be here. We know your workload doesn't go away by virtue of being here. So thanks again. Mr. Sessler.
Mr. Chairman, appropriate time, I'd like to be recognized and make a motion.
I think this would be that time.
Mr. Chairman, I'd like to make a motion to do pass HB 87, Committee Substitute LC 294654S.
Mr. Sessler makes a motion of due pass of House Bill 87 by substitute LC 294654S as in Sam, second by the Vice Chairman Representative Mark Hatfield. Are there any amendments? Ms. Abrams.
I'd actually like to make a substitute motion.
Ladies recognized to make that motion.
I'd like to make a motion to table. While I appreciate and recognize the work that Mr. Ramsey has put into this bill, I think that this bill continues to have several constitutional and substantive impediments that I think could harm the state of Georgia. I think that Section 11 traffic offenses have historically been utilized to warrant racial profiling, and traffic offenses are benign but wholly subjective, and that this creates a legal fiction that will not only unduly harm the individuals but will harm industries, especially the tourism industry in the metro Atlanta area. Further, I'm concerned that the creation of a private cause of action against local governments constitutes basically an unfunded mandate. Most local governments do not have the broad resources of legal counsel in-house. Most of them will have to engage outside private counsel, and 45 days of private counsel and the ability of any citizen to lodge a complaint, I think, creates a fiscal nightmare. Arizona has already seen $140 million worth of losses simply from having this bill on the books, even without most of its provisions being implemented. And Georgia has a much more substantive tourism industry and a much broader base of visitors and residents here. And so I'm deeply concerned about the impact of this bill on the bottom line of the state at a time of economic downturn. And so would ask this body to table this bill.
Ms. Abrams moves that House Bill 87 by substitute LC 294654S be tabled. All in favor of the lady's motion signify by saying aye.
Aye.
Opposed?
No.
In the opinion of the chair, the noes have it, and the motion fails. The standing motion is of due pass by substitute of House Bill 87 LC 294654S. Are there any amendments?
Mr. Chairman, I
Mr.
have
Setzler.
Oh,
I mean, Mr. Ramsey, sorry.
on line 380, Ms. Travis, this is one she caught after she sent the sub out last night. The word "where" should be "when." It's just a little technical error. If I could offer it as an amendment to replace on line 380 the word "where" with the word "when."
Mr. Ramsey proposes amending on line 380, striking the word "where" and adding in the word "when." Is there objection to the amendment? Hearing none, the amendment is adopted. Are there any further amendments? Seeing none, all in favor of the gentleman's motion of due pass by substitute of LC 294654S signify by saying aye. Aye. Opposed? No. The ayes have it, and the motion is adopted. We are adjourned. Thank you very much.